Welcome for medical legal framework, and of course, I believe that you're doing well. So, this course unit is basically to introduce you into some of the legal practices, some of the rights towards the protections of the patient's information that is very paramount for the professionals who are in the fields of information management and records. So, it is very obvious that a good information that is being protected should also have the guidelines, should have laws that protects how the informations are used, how informations are requested, and how practices should be implemented. So, these units take concerns of several policies, several guidelines, and looking into some of the aspects that are very necessary and important in the practice and management of health informations. So, how do we define medical legal framework? I define medical legal framework as the principal law concerning the protections and use of personal and clinical medical informations from authorized users. Defined as the principal law concerning the protections and use of personal, clinical, and medical informations from unauthorized users. So you're going to do me a favor and quickly do a corrections here, please. There should be unauthorized users. Okay, this should be unauthorized users. So you do the correction from your material as well. All right. So, the medical framework is based on good medical practice. It is a core ethical guidelines for doctors, for you, the medical records of practitioners, the medical practitioners, and any other persons, because it is set values, it is set principles on how things should be used, how things should be utilized within the practice of medical and ensuring effective service deliveries within the healthcare systems. So, the aims of medical legal framework is, first of all, to state the duties of the health professionals in healthcare service delivery, to set limitations. The limitation is set on the things that you are supposed to do and things that you are not supposed to do, because within the practice of every services, we have the responsibilities. So in these responsibilities, you are not supposed to be responsible for everything, and you are not supposed to take concerns of everything. So you have a limitations for the services that you're supposed to deliver to your people, and therefore that limitation is set by the availability of the laws and guidelines that are available within the practices of the services. So for example, if you have given your job descriptions, you deliver your services within your job description that has been given to you. This helps so much on ensuring that there is specialities and perfectness in basically effective services being delivered, so that you focus on things that you can do better, and then you leave the things that can be done better by another person to those who can handle it, and also things that can be done better by you should be left for you. So one of the aims of legal framework is also to protect and maintain standards in quality assurance, ensuring that the quality of the services that are given to people are actually of good quality, are actually of good standards, and this is only possible when there is availabilities of the laws, availabilities of the principles or the guides that tells or direct professionals or practitioners in what they shouldn't and what they should do. And next is also establish methods of regulatory professional behaviors, and this is a recipient of disciplinary actions or procedures. So basically, of course, if there is a law, the law states what you should do and the punishment of otherwise, meaning that if the guideline states that, please, for example, if you're sharing any information to any personal users, you must make sure that you consider the consent of the patient. And in case otherwise you don't consider this, of course the law comes in because you actually fail to follow the guidelines that has been instructed under the legal practice. So that is where this understanding, the concepts within this are actually important. Next is also to promote continued professional development. How does it promote continued professional development? Definitely, if you really understand the requirement, for example, if your job descriptions is beyond your qualifications, what does it take? That's the reason why some of you will be thinking about going back to school and then add value, or going back to school and then add more qualifications. You have certificate, you go back to school, and then you had diploma. You have diploma, you go back to school, you had degree. You have degree, you go back to school, you had masters, like that. So that is what actually legal practice, the framework of legal practice is able to present. And the next is protecting the allied professionals. So the law, the guidelines, is basically not to be against you, the practitioners. It is to protect your interest, protecting your legal interest, and at the same time protecting the legal interest of the beneficiaries or the consumers of your services. Yeah. So we have some of the components of the medical legal framework. For example, responsibility to patients' right. You're responsible for patients' right, and then ensuring that the patient information are always safe. Be concerned about interpersonal relationship, and basically that is being responsible for you and the colleagues, and then also being responsible to colleagues and fellow health workers, responsibility to information confidentiality and privacy. Yeah. So right here we have the importance of medical legal framework. Medical legal framework. As a law, it of course consists with several principles, several guides, and this is very important. Okay, this is very important. But when you talk about the aims, you can be able to relate that with what we have available here. So you're going to take your moment. Ole, Francis. So one of the importance of the legal framework is it gives the statistical compiler a clear mandate to collect data and to compile and disseminate the informations. So what it states is that, for example, within the rights and the legal procedures being presented to you, you know what to do. You have a complete freedom to really collect information under your authority. And this authority has been or is granted by the legal framework within the system. And also it elevates or maybe facilitating the collections of relevant informations. In most cases we actually collect information that in other words would have been wrong to ask such kind of information, but it is accepted because the intentions of collecting such informations is under the legal framework that has been implemented, that has been clearly indicated. So it gives you the privilege to collect informations that would have been unethical if without the guidelines that is being put. So due to the availability of the legal frameworks, the guidelines, the principles, and the laws, you have the potentials of collecting the relevant information that you need in order to add into the information that you have. For example, asking for patients' age. In one way or the other, age, first of all, is a confidential information. So without the availability of this principles, without the availability of these guidelines, asking for these informations would actually be an offense. And the reason why it is not a problem in the facility, because it has been indicated, clearly stated under the legal framework of practices. So it also first, helps identifying and defining the national competent authority and the roles of governmental agencies in particular statistical domains. So not only you as an individual, that these concepts will help you to understand the role that you're supposed to play, but even at national level, even the government, even the authority, for example, the public health sectors, these all give them the guidelines on what they should do, what they shouldn't do, and what comes as a result of the punishment for their omissions or omissions. All right, so I would actually want you to be able to get into some of this. Please, I'm not going to go through each and every single words. In areas that are really simple, easy, I believe that you can understand, because you are not in the first semester, you're not starting the thing, you've been in it, and definitely you're finalizing. So I've talked about that before, and I'm sure that you're with me. And in case of any complaint, in case of any problem, in case of any difficulties, kindly don't hesitate to come into my inbox and we discuss whatever it is, or be able to post that questions within our platform, and definitely I'll be able to get back into that. So we have some of the legal aspects of medical records and maintenance. Legal aspects of medical records and maintenance. So the legal aspects of medical records and maintenance concerns with how the information should be collected, how the information should be documented throughout the provision of services within the healthcare centers, and then the kind of information is contained within the medical record must be considered as something confidential, and which means when it comes to the storage, there are a few things that must be put into considerations. The questions like how safe is the information from unauthorized users, how safe is the information from the hazards or anything that can cause deteriorations on the records. This is very important. This is very important. And we already know what medical records consist of. Medical records consist of patient medical history, clinical findings, diagnostic test results, pre-operative care, operations notes, post-operative care, and daily notes of patients' progress, and then medications. So which means these are all confidential information that should be protected from unauthorized users. And therefore, we must understand, if not, even if in the absence of the medical legal framework, we still need to be able to understand that there is need to keep this information confidential. There is need to keep these informations from the access of unauthorized users. Why? Because it contains information that are pertinent towards the patient's health. So it is very important if we are to practice our services prevalently, and then there is need to understand that. Now, under the medical legal concepts and maintenance, we have confidentiality. We have confidentiality. We have what we need to consider whenever we should disclose the information to unauthorized users, or maybe even at times to authorized users. Okay, so for example, the confidentiality basically concerns about how safety is the patient's information, and what is the balance in the respect of the patient's right. So, like I've talked about confidentiality in several occasions, and of course we define confidentiality as a right of individual to have their information kept private. So you have a right, and that is the rights to ensure that your information are kept from unauthorized users, your information are being protected from people that should not be able to glance on the information that is written about you within your medical records. So you'll get time probably, and then you briefly summarizes the aims of legal aspects in a medical record practice. So right here we define confidentiality as the right of an individual to have personal identifiable medical information kept private. Such information should be available only to physicians of records and other healthcare and insurance personnel as necessary. So basically, you need to understand that, like I said before, you've talked about confidentiality several times. So patients' information should definitely belongs to few people that should be able to have access to such informations. Now the question is, what are the important aspects in maintaining patient confidentiality? What are the important aspects in maintaining patient confidentiality? Number one, you should be able to recognize or understand and perceive that the responsibility of protecting patient confidentiality is an obligation for all staff in a facility. Whether you are an external staff or you are volunteers, you have a full responsibility to ensure that confidentiality must be protected. And also, recording patient information accurately and consistently. One of the most important things is basically having the misspellings of patients, and as a result leading to patient treatment inaccuracy. So that's very wrong, and we should emphasize on ensuring that the information is being generated correctly, and then keeping patient information private, and then for keeping patient's information physically and electronically secure. Now sometimes, why are we talking about this? In most cases, someone may think that, of course, if I'm keeping patient information using a computer, of course I don't need to worry about any protection because my computer will always be shut down, but doesn't have encryptions, does not have password. So this lead to easy access by anyone accessing the patient informations. So whether you are keeping them physical or manually, or you're keeping them electronically, ensure that they're always secure. How do we secure electronic records? For example, we need to have a password that is changeable periodically, must be changed so that people cannot get used to a password and having access to the records. And two, we must be able to protect them from cyber crimes, the hackers, etc. And then ensuring that the center of these informations are put far away from people that should not access the informations. So next is disclosing information with appropriate care. How do you disclose information with appropriate care? Of course, if you're releasing information, you must understand who is taking the records and why, and what's destinations, for what purpose, and how long are you going to take. We talked about these record requests in record identifications in the previous time. So you must be very careful. Being careless is when anybody comes in, you because you know him, you build trust in them, and then just give them information without collecting particulars that help you in tracking the movement of such records. So as a result, the persons will end up saying that I really didn't pick anything from your office, and therefore you don't have evidence because you never collected any records. So that is what we mean by disclosing information with appropriate care. You really need to be very careful. Okay. Now we have what we call a model of confidentiality. There are three concepts under which confidentiality is being considered. Okay. And which confidentiality is being considered, and some of the circumstances where the confidentiality is not being considered. So what we are saying is that the more which can be used in to aid decision making in disclosure situations. So there are three distinct flow charts which distinguishes three sets of circumstances. Number one, where it is proposed to disclose confidentiality information in order to provide health care. There is nothing wrong with that. Yeah, so if the intentions of disclosing the information is strictly for the patient's care, and that mean this kind of request would be coming from a medical doctor or maybe a service provider, there's no need to seek for the patient consent in this case. You just need to track maybe the movement of the records. You may need to record few things, basically for the purpose of tracking who have taken the records and for what purpose. So you may need to know who is taking the record and which department is the record being taken to. That is purposely for tracking the movement of the records, but not because of what? Confidentiality. Two, where the purpose is not healthcare, but it is a medical purpose as defined in legislations. And also, now we are saying sometimes the reason under which the records may be requested sometimes, as we are considering confidentiality, may not actually be for the purpose of healthcare, but the purpose of such request may be defined, maybe one of the legal aspect being defined in one of the guides and the law practices. So, for example of this is when the need to review the records or the request is coming from the lawyers, from the police. These people have a legal obligation. They are accepted. So there's no need to look at confidentiality rights at that point. Those are the limitations. So this three model talks about the limitations, where the confidentiality is not absolute. And three, the purpose may not be related to health care or even medical purpose. Okay, so sometimes this may be definitely not about the patient's care, not even about anything. But if it is under the obligations of the law, then it is accepted. In that case, you may need to release the patient's medical information. So basically, confidentiality is one of the key things that is required in the practice of medical records and information protections. Because we really need to keep the patient information between the information that we know about patients should remain within us and the people who understand the levels, the limitations of confidentiality within the healthcare systems. So we got some of the few things that you will go through them bit by bit, and I'll be delivering you with revision questions that will help you to go through some of this. So we have the limitations, which is widely explained. Limitation of confidentiality, where the law is accepted and where it doesn't. So those are points that I've summarized and doesn't need any further explanations. And then out of that, some of the things that we might have not talked about, the details of the patients that should be considered confidential. So what are they? You should get to know them, the names, the personal details, the bank details, and all that. Yeah. So I got a coursework here. Coursework A, Group A, and Group B. But since you are alone, you will actually be able to answer or work on question of Group B. Please listen carefully. These questions of Group B, all of you will do it, and that will serve as the coursework tests. Please copy it down, or if you have printed this hard copy, you underline this and you do it as questions as a coursework test. Of course, you know how to handle it as usual. Kindly be able to drop it. Now, this area where it is written or colored with the red here, this area here, red, kindly ignore it. You can cross it if you have a hard copy. Kindly ignore that area. Don't even read it, but you can read it at your own time if you want, but you can ignore it because we have nothing to do with that. Okay, those are areas that has been updated already. Unfortunately, I couldn't, but I think I can be able to delete it, so you can also delete it from yours. Okay. Yeah. So those are. Yep. So All right. So here talks about ensuring confidentiality. Ensuring confidentiality. The questions under this is that how do we ensure a patient confidentiality? How do we ensure patient confidentiality? Okay, you can be able to write it down. How do we ensure patient confidentiality? So we are saying that to ensure patient confidentiality, workers, a little update there please. Workers should only access confidential information for work that is covered by their job descriptions and the policies and procedures of the organizations. So we are saying that let the access of these informations be for a purpose, and the disclosure of these informations be for a purpose. So you don't go there and then retrieve the information just because you are bored. Just like the legal law says, and the request policies, that no record should be removed from the medical record department except for patient's care. That means if the purpose of removing the records is not for patient's care, then there is no need for that. Yeah, so you'll be able to really tap on that briefly. All right, while I say something about patient privacy. Now, the difference between confidentiality, we already talked about confidentiality. So privacy is actually also the patient's right. And this rights determines who uses the patient informations, how they use it, and to what extent is the information is being shared to other people or with the other people. You get the point? So the other one ensures that the patient information is kept private. This one may allow you to use to share the information, but the question is, who are you sharing the information with? And how are you sharing, and how will they use it? And to what extent? It means that, are they going to use all the information? Are they going to read every information? Do they need all the files? Do they need to see my names as a patient? Do they need to see my diagnosis? Those are the extents that are considered. Right? So we are saying that it also involves maintaining confidentiality and sharing identifying data known as protected health informations. So this means that the healthcare providers should really be in position to understand who is accessing the informations and for what purpose, and to what extent do they want to use the informations. So this right belongs to the patients, and you have the responsibility. Okay, so that's the difference between the confidentiality and the privacy. Okay, so we have some of the principles of patient's privacy. Principle number 1 is the right to privacy is personal and fundamental. 2, medical information is maintained by physician is privileged and should remain confidential. It's a principle, it's a law, it's a guide that should be followed. So 1, you should take the patient's rights to privacy as a personal fundamental right. Personal fundamental right. So there's no jokes with the patient's information. It is their fundamental rights to know who uses their information. So actually, when this information is in the hospital, they know we are using the information, and they don't care about the extents, because we know the extent that we can use the information. So this is for you to protect these informations from unauthorized users or people that really need to have limited access to these informations. Right. So we got the release of the informations. When you are thinking about releasing the patient information in respective of the privacy and confidentiality, there are a few points that you should keep in mind. Number 1, you should be aware of the name of the institutions or the name of a person who is taking the informations. Why do they want to get the informations? Getting the patient consent, the extent and nature of the users, and then the details of the legal representative to receive the information. All this are things that you should consider when you are thinking about releasing of informations. Now, we have two methods of releasing patients' medical records. We have one of the way that release information directly, or we allow people to access the information directly, and we call it direct access, where people can access photocopy, whereby someone can photocopy either the whole document or a half of it. That is direct access. And then verbal release is definitely when the information is either released in a court of law, or maybe the information is read for the users to take note of. Okay, so these legal aspects of releasing medical records and release of health informations, they are actually the same. You get, they're actually the same. This one has 6 points, and this has around also 6 points. Okay, they are the same place. This area, they are actually the same. That is definitely a typing error, so you will definitely ignore that. You will ignore that area that I have identified there. I'm putting it in a different color. Okay, you ignore that green area, please. Ignore it. From legal aspects of releasing medical records, it's the same. You can either use it and you ignore this one, or you can use this one and ignore this one. Okay, all right. So allow me to meet you next time and summarize medical negligence, malpractices, and we make a conclusion. Either way, thank you for today.